I have lived in Modesto since 1984. When I first came to Modesto, I worked for California Rural Legal Assistance, and even though I couldn't do immigration law at CRLA, I worked with a lot of immigrants there. And I went into private practice in 1995 and started my own immigration firm. And I was really interested in immigration from the time I was in law school. I clerked briefly for Cruz Reynoso when he was a select commissioner on immigration and refugee policy right after I got out of law school. So it's been an issue that I followed and have worked on for many years now. They designated me to speak mainly on the new law that's being proposed. And I'm going to be perfectly honest, I have not been following the developments going on in Congress because over the years my experience has been that we have had so many proposals come through, and when I've gotten really excited and thought that we were going to have solutions that were going to solve the problems of so many of my clients, it's only turned into disappointment. And so it's not because I've been lazy, it's just frankly I didn't want to get my hopes up and the hopes of my clients up until I knew what the legislation would actually be. As you all know, if you've been following this, politically this thing was almost dead last week. It's been resuscitated. And when I went to the American Immigration Lawyers website this morning, they're voting on something called cloture right now, and they're trying to limit the number of amendments that are being offered to the legislation right now. So it's still alive. So let's talk about some of the main provisions and how those might impact our community. I'm going to give you the good news first because once we get into these specific provisions, there's a lot of bad news in this law. And you'll see why when we get into it. One of the really good things about this law, and it's good, there's somebody here from the Stanislaus County Office of Education, if there are any educators here. The good news is for kids who have graduated from high school and who are going to college and want to go into the military. There's a portion of this that's called the DREAM Act. And I apologize that I don't know this better than I can't work without notes, but it's, I thought you would be interested in some of the specifics, so I'm just going to read some of these off. What the DREAM Act will do, it will, people who qualify will be those who have lived here continuously since January of 2007. They must be under 30 years of age on the date of enactment. They must prove that they were under the age of 16 at the time they entered the United States. They must show that they have a high school diploma or a GED. In addition, they have to prove that they haven't been absent from the United States for more than a year, 365 days, during their period of conditional residence. They must have acquired a degree from a U.S. higher education institution or completed 2 years in a bachelor's degree program or higher at such an institution. So if you have students who have finished their 2 years at MJC, they're going to qualify for this. Or they have to have served at least 2 years in the military. They also, they're going to have to be required to provide a list of the educational institutions that they attended, and they're in compliance with other eligibility and admissibility criteria under the same as what the Z visa people are going to have to meet. And what that's really referring to is you have to show that you haven't been convicted of certain crimes, you're a person of good moral character, and that you haven't been deported before, certain issues like that. What's really good about the DREAM Act is there's no numerical limitations. So it's unlimited number of visas will be available for people who qualify for this. And that's really good news. Also, it looks like they're going to be exempt from paying certain penalties that other people are going to have to pay. So, and when you hear about what the fees are going to be for the other visas, this is one of the best portions of the legislation. And I'll add, the DREAM Act has been something that's been proposed on several other times, several other occasions. At one point, it was Senator Orrin-Hatch and Senator Kennedy that were trying to get it through, and they couldn't get it through before. But anyway, this is like the best part of the best part of the whole proposal as I see it. So let me talk about some of the other things. There are a number of you here I know are familiar with the current immigration system, and I think the biggest shock in this legislation is how much we are going to get away from the current system. We're going to move away from what they call we're going to move towards a merit-based system, and we're going to get away from having basically people come here just to be reunited with their families and to join their families. What this legislation will do, well, let me go back and explain the way the current system works so people will understand. Family immigration is primarily what I do, not employment-based immigration. The way most people immigrate now through family members is you are either classified as an immediate relative. If you're an immediate relative, you are the spouse of a U.S. citizen or the minor child of a U.S. citizen. If you don't qualify, or you are the parent of a U.S. citizen. So that gives you immediate relative status, and for people who are trying to come to this country, it's the most straightforward way to come here as an immediate relative. There isn't as much of a waiting time to get your visa, and then once a visa is available, you either adjust status abroad through the consulate and come here, usually within a year. Here in the United States, if people have entered the country legally and they're eligible to adjust here, it's a pretty straightforward and quick process. The immediate relative category will remain under the changes that are set, with the exception of parents. Parents will no longer be classified as immediate relatives. They're going to set up another category for them. And what it seems that Congress is doing with this is that our Congress has kind of taken the attitude that we are not going to be the retirement home for the rest of the world. And they've just carried that one step forward. It's not going to be easy for you to bring your aging immigrant parents here anymore. They're going to they're going to be put into a new visa category, and there are only going to be a certain number of visas available. So that's one of the things they've done. Now, under the current system, if you're not an immediate relative, then you're classified there's 4 other categories. Actually, it's a little bit more. It's 1, 2A, 2B, 3, and 4. First preference consists of sons and daughters over the age of 21 of U.S. citizens. 2A is spouses and children under the age of 21 of lawful permanent residents. 2B, children, sons and daughters of lawful permanent residents over the age of 21. Third preference, married children of U.S. citizens. And fourth preference, brothers and sisters of U.S. citizens. What happens under the new legislation is those categories are gone. 1, 2A, 2B, 3, and 4 are gone. Although one of the things that happens is the people who were 2A previously, the spouses and children of minor children of lawful permanent residents, they will become like immediate relatives. So that's good. But if you have kids over 21, if you have married kids, if you have your brothers and sisters you want to immigrate here, it's going to be real difficult for them. And how are they going to be able to immigrate? We're going to have this new merit-based system. And the same merit-based system, well, in addition, I should go back here for people who know something about employment immigration. The way our current system is now, also there are different preferences, different categories of visas that are available for people depending on their skills, and there are different employment visas. And those employment preferences, the first, second, and third categories, are also going to be eliminated. So what are we going to have instead? We're going to have a merit-based system. And these merit-based systems are being used in some countries. I think Australia is one country that uses it, and I'm not familiar with others, but they've been around. And where there's going to be a possible of 100 points that people can get to come here. And this is the way they're breaking it down. They will assign merit points, and depending on your merit points, you'll have a better chance of coming or not. If you are you'll get merit points based on your employment, and you can get up to 47 points for employment. You'll get merit points for education. You can get up to 28 points based on your education. You can get merit points based on your knowledge of English and American government and civics. There's going to be 15 points that you're eligible for there. And then if you have extended family here, you can earn up to 10 points. So under this system, it's obvious the better educated you are, the better employment you've had, the easier it will be for you to immigrate to the United States. I look at this and I think of my own family. My father's from the Azores, had a second grade education, and I just look at this and wonder if my family would have ever ended up here under this system. Although my dad was a small businessman, and we actually came to the United States in the 50s based on a business visa that my dad was able to get. But what else can I say about this? They've created this other category. They understand that there are going to be hardship situations where people are basically not going to be able to be reunited with their families. So Congress was very generous in providing 5,000 visas. 5,000 is nothing, people, for hardship cases. And let's see, what else about this category was... Now, the one thing about this system, it sounds like the full effect of it, it's going to be felt by people who filed visa petitions after May of 2005. So people who had visa petitions prior to May of 2005 will still, their cases will still be adjudicated under the old system. And one of the things they're doing, there's such a backlog of old cases. I mean, to give you an example, if you are the son or daughter over the age of 21 from Mexico of a lawful permanent resident, you have been waiting more than 15 years for your visa date to come current so you can finish the process. One of the things they're going to try to do is they're going to try to wipe out those backlogs, and they're going to give a lot more visas to try to deal with those backlogs. So they're planning to do 440 visas per year to get rid of those backlogs. But once the backlogs are eliminated, they're going to drop the number of visas substantially. So anyway, having read this, having reviewed it, I can tell you based on the kind of immigration work that I do, I'm glad I'm not a young attorney anymore, because I'm wondering how much work I would have after this goes through. Anyway, this part of the work this part of the legislation doesn't give me much hope that I'll have much work left, but there's another part of it that makes me feel like I'm going to have lots of work. So let me talk about that part of the legislation. They are going to create a new visa that's going to be called the Z visa. And in order to qualify for the Z visa, it's going to be easy to qualify for it. You only have to show that you've been physically present since January of 2007. You must be admissible, which means that you don't have crimes, you don't have these prior deportation orders, those kinds of issues. And you have to show that you're working and that you're going to continue performing labor services, or you're currently being educated. The good thing about the Z visa is that your spouse and your children under the age of 18, on the date the application is submitted, they will be eligible for Z visas right along with you. Now, let me talk a little bit about the kinds of people who won't qualify for Z visas. And then they've kind of mimicked some of the old amnesty language on this. If you've been convicted of a felony, you don't qualify. 3 misdemeanors, you don't qualify. If you've been convicted of 1 crime of violence or 1 crime of reckless driving or DUI, you won't qualify. If you entered or attempted to enter the United States after January of 2007, you won't qualify. If you can't establish that you are a person of good moral character for 3 years prior to filing for the Z visa, you also won't qualify. I'm not going to, anyway, they look at mainly criminal behavior to determine whether you're a person of good moral character or not. Now, the real big problem with the Z visas is paying for one. The costs are exorbitant. And this is how it breaks down. The initial fee for the first beneficiary is $1,500. The principal applicant, let's just say you have a mom, a dad, and 2 kids. Okay, dad's a principal applicant. He's the one who's working. Dad would pay $1,500. He would pay a $1,000 penalty. Then he would also have to pay a $500 state impact fee. So for dad alone, dad's going to pay $3,000 for his application. In addition, the kids are going to have to pay, he's going to have to pay $500 for each of the kids, and they're also going to have to pay $1,500. So dad's going to have to pay $3,000, mom's going to have to pay $2,000, junior's going to have to pay $2,000, and little sister's going to have to pay $2,000. So for a family of 4 to file to get a V visa is going to cost $9,000. Now, this goes back to sort of my unemployment act thing. I can't see, so few families are going to be able to afford this. And then it gets better. So let's say they're able to scrounge up the money and they get they file and they get their V visa. Then what happens? The visa is good for 4 years. At the end of 4 years, you have to file for an extension of the visa. And the thing about it, you can request unlimited extensions. You can be on a V visa forever. But when you go in to apply for your extensions, the fees that they're set now, they're $1,500 per beneficiary. So that family of 4 I was talking about, when they go in for their extensions, they're going to be paying $6,000 for their extensions. So $9,000 in year 1. 4 years down the road, they're going to have to pay another $6,000 to go ahead and renew their visas. And the thing is, the way they've set this up, you have to renew. You have to stay in status, and Nellie will appreciate this. If you are late or you don't get it in before the first one expires, you're out of luck. So it's real important that people file on time. And I can tell you, based on this, money's going to really be an issue for a lot of people. Now, people will be eligible to file for, after the 4 years, they'll be eligible to file for permanent resident status. But they won't be able to do the application here. They'll have to leave the United States and go back to their country for consular processing. And the media has made a big deal about that. And frankly, that's not such a big deal. Frankly, that was the way it used to be done prior to the enactment of 245I. Most people would leave the country and if they were from Mexico, they'd go back to Tijuana and they would go to their interview there, and they would have, they'd stay there a few days, get their medical exam and all that, and then they would get their passport stamped if they were approved, and then they'd just come back. So they kind of envision that same process. What's been difficult for people now is if you've been out of status illegally here for more than a year and you leave the country, then you're subject to certain penalties. There's a penalty that says you can't come back for 10 years unless you can show that your U.S. citizen or lawful permanent resident spouse or child is going to suffer extreme hardship if you can't come back. The only thing is, it takes so long to adjudicate those waivers that sometimes people who leave they end up having to stay outside the country for many months before they get the waiver and can come back. So the good thing is the unlawful presence issues, they go away with this C visa, so people won't have to deal with that problem. But the biggest issue is I think the biggest problem with this is just the expense. It's going to be very difficult for people to pay this. So that's a little bit about the Z visa. Oh, wait, and I should add one more thing. The merit-based system kind of dovetails with this. 20% of the 20% of the permanent resident visas that are going to be made available with the Z visa people are going to be adjudicated with that preference system. So, 20% of the people going through the Z visa process will be subject to that, that point system. So it's pretty obvious that the people probably who would be filing for the Z visa, the people I envision who can make the most out of this are people who maybe came here on some sort of an employment visa, they have really good jobs, and then the requirements get really technical when you're here on an employment visa. You have to work for the same employer, and sometimes if you move, sometimes people, they haven't kept working for the same employer. They've tried to move around, and so they've lost status, but yet they may be an engineer or something. Well, they may have the resources to go ahead and apply under this, and they would be the ones who would probably be able to pay the fees and would benefit from this merit-based system. So, those are the people who are going to really benefit by this Z visa system. I may have said V because, anyway, that's another type of visa, sorry. In addition to this, there's ag jobs. And under ag jobs, the way that's going to work, they will get priority adjustment for a green card if they can prove that they performed at least 5 years of agricultural employment for at least 100 work days per year during the 5-year period beginning on the date of enactment, performed at least 3 years of agricultural employment for at least 150 work days per year during the 3-year period beginning on the date of enactment, or C, during the 4-year period beginning on the date of enactment, they worked at least 150 work days during 3 years and 100 work days during the remaining year. I want to tell you it's difficult to sit before you and sort of go through this and say, I don't want you to think that this is the law, because it's not. And again, I want to go back to sort of that caveat that I gave at the beginning. We could see a lot of changes before anything is ultimately finalized. So, I don't want to see people running off, this is going to happen. Every time I tell people this is a proposal, it's not the law, it hasn't been signed. I still get, it's funny how people still call the office, we heard there's this new law. No. No, nothing's been passed yet. So, anyway, some of these provisions are scary. They're still trying to iron them out. I'm sure that if I'm looking at this and have all these concerns about, basically people being able to apply for things based on the cost, that those same kinds of concerns are going to be discussed in Congress and hashed out there, and so we'll see what they ultimately come up with.